Article 35 of the Family Code of the Philippines provides the following marriages shall be void from the beginning. 1. Those contracted by any party below 18 years of age, even with the consent of parents or guardians. 2. Those solemnized by any person not legally authorized to perform marriages unless such marriages were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. 3. Those solemnized without license, except those covered by the preceding chapter. 4. Those bigamous or polygamous marriages not falling under Article 41. 5. Those contracted through mistake of one contracting party as to the identity of the other. And 6. Those subsequent marriages that are void under Article 53. So let us define first what is a void marriage. So, a void marriage is that which is not valid from its inception. So, it is one that is legally considered invalid from the moment it is contracted. It has no legal effect and it is as if the marriage never happened. So, in Article 4 of the Family Code, declares that the absence of any of the essential or formal requisites for a valid marriage, as provided for in Articles 2 and 3, makes a marriage void. Exceptions are, however, provided for in Articles 27, 28, 31, 32, 33, 34, and paragraph 2 of this article. In addition, Articles 35, 36, 37, 38, 40, 41, 44, and 53 in relation to Article 52 of the Family Code enumerate marriages which are void. So let us discuss the first paragraph of this article. So, 1. Those contracted by any party below 18 years of age, even with the consent of parents or guardians. So, under Article 5 of the Family Code, it is required that both of the contracting parties must be at least 18 years of age. So, a marriage contracted by any party below 18 years of age is void from the beginning. This rule is absolute and does not admit of any exception. So, even if the marriage is with the consent of parents or guardians, the same is still void ab initio due to the absence of legal capacity, which is an essential requisite for marriage. 2. Those solemnized by any person not legally authorized to perform marriages unless such marriages were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. So, marriages solemnized by any person not authorized to perform marriages are generally void ab initio. Article 7 provided the following persons who are authorized to solemnize marriages. So, we have here incumbent members of the judiciary within the court's jurisdiction, priests, rabbi, imam, or ministers of a church or sect subject to the conditions laid down in Article 7, paragraph 2, ship captain or airplane chief, in cases mentioned in Article 31, military commander of a unit subject to the conditions mentioned in Article 7, paragraph 4, and Article 32. We also have consul general, consul, or vice consul in the cases provided in Article 10, and mayors. So, if a person is not among those provided in Article 7, or if he is among those enumerated but does not comply with the specific requirements for his authority to vest on him as provided by law, he has no authority to solemnize marriages. The rule, however, is not absolute. Even if a solemnizer has no legal authority to solemnize marriages, so long as either or both contracting parties believed in good faith that he had the legal authority to do so, the marriage is still valid, not only with respect to the parties of such marriage, but also with respect to third persons and the state. So the term good faith, when used in connection with putative marriage, means an honest and reasonable belief that the marriage was valid at its inception and that no legal impediment exists to impair its validity. A finding that a person entered a marriage in good faith is equivalent to a finding that he or she was innocent of fraud or wrongdoing in inducing or entering into the marriage. So, the good faith referred to in this article, paragraph 2, must necessarily be one that is based on a mistake of or ignorance of facts and not based on ignorance of law, following the principle enunciated in Article 3 of the new Civil Code that says ignorance of the law excuses no one from compliance therewith. So these are the sample cases which involve ignorance of facts. One, where a person posed as a priest and either or both of the parties are not aware of the deception. Two, where a religious solemnizer is not duly authorized by his church or sect to perform marriages, but either or both parties are not aware of such facts. Three, where a religious solemnizer is not duly registered with the civil registrar general, but either or both parties are not aware of such facts. And four, where the religious solemnizer acted beyond the limits of his written authority, but either or both parties are not aware of such facts. Paragraph 3. Those solemnized without a license, except those covered by the preceding chapter. So, marriage license is a formal requirement, and its absence renders the marriage void ab initio, except those enumerated in marriages exempt from the license requirements in Chapter 2, Articles 27 to 34 of the Family Code. Paragraph 4. Those bigamous or polygamous marriages not falling under Article 41. So, bigamy is a crime punishable under Article 349 of the Revised Penal Code, and it is committed when a person contracts a second or subsequent marriage before the former marriage has been legally dissolved or before the absent spouse has been declared presumptively dead by means of a judgment rendered in the proper proceedings. So, such second or subsequent marriage is void ab initio for being bigamous, even if the other party had acted in good faith and was not aware of the existence of the previous marriage at the time of the celebration of the subsequent marriage. The rule, however, is not absolute. In Article 41 of the Code, a subsequent bigamous marriage may be considered valid if all the requisites required under said article are present. Paragraph 5. Those contracted through mistake of one contracting party as to the identity of the other. A marriage contracted through a mistake of one contracting party as to the identity of the other is void from the beginning. For the marriage to be rendered void, it is important that the mistake in identity must be with reference to the actual physical identity of the other party, not merely a mistake in the name, personal qualifications, character, social standing, etc. There is here an absence of real consent, which is an essential requisite of a valid marriage, thereby rendering the marriage void ab initio. So we have here an example situation. The bride you're about to marry has a twin sister, and you are marrying not the person that you intended to marry, but the twin sister of that person. Okay, let's go now to the last paragraph of this article, which is Article 35. Those subsequent marriages that are void under Article 53. So, if a previous marriage has been annulled or declared a nullity in a final judgment, the effects includes liquidation, partition, and distribution of their properties, if any, and in proper cases, the delivery of the children's presumptive legitimes. The law further requires the recording and registration of the following in the appropriate civil registry and registries of property. So, first, the judgment of annulment or of absolute nullity of the marriage, the partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitimes. Only after complying with the foregoing requirements may either of the former spouses be allowed to contract another marriage. If these requirements are not complied with and either of the former spouses contracts another marriage, the subsequent marriage is void ab initio.